Welcome to Roman Manor. This lesson will explore the basic elements of a criminal offense. Specifically, we will cover the elements of concurrence and causation as understood by both the common law and the model penal code. A quick word of caution, this course is intended to answer academic questions only. These materials are intended to reinforce your legal education or to satisfy the curious layperson, not legal advice. And with that, let's get to it. This lesson's purpose is to provide an in-depth look at the third and fourth elements composing a crime, the elements of concurrence and causation, in order to better understand the specifics of all criminal offenses. This lesson will proceed as follows. We begin with a brief lesson introduction, discussing why these elements are necessary. We then examine concurrence, before looking in depth at causation from the perspectives of both the common law and the model penal code. We then conclude. So let's begin. Concurrence, as an element, refers to a state that must exist in order for a crime to have occurred. Namely, this means that a crime's actus reus and mens rea have occurred at the same time. This is straightforward. An act or conduct leading to the harmful result must occur with a culpable mental state, and vice versa, before culpability can attach to the actor. For example, think of a sniper on a tall building preparing to kill his target upon her exit from an office building. While setting up, he knocks loose some bricks that fall several stories onto a passerby walking on the sidewalk below, killing them instantly. Here, it's unlikely the sniper would be found guilty for murdering the passerby. A culpable mens rea did not accompany the mens reus, the knocking loose of bricks that killed the passerby. Further, the mens rea he did possess, either malice of forethought satisfied by intent to kill under the common law, or acting purposely under the MPC, did not accompany the loosing of the bricks. That mental state existed toward the exiting office target, not toward the passerby. Just keep in mind, the actus reus and mens rea must occur simultaneously. Causation as an element refers to the connection between the actor's conduct and the resulting harm. Society designs criminal law to prevent future harms against it by inflicting punishments sufficient to deter potential wrongdoers. Punishments can be quite severe. It can include heavy fines, incarceration, and in some instances, death. Considering this severity, the prosecution must show the actor's actions resulted in the harm to be prevented or deterred in order to justify the punishment's application. In tort law, the student learns that causation is composed of two subcomponents. 1. The actual cause, also called the cause in fact, and 2. The proximate cause. Causation in the criminal law context is understood under the common law to require the satisfaction of those same subcomponents. As we have said, under the common law, causation relates to criminal law in much the same way as it does to torts. A prosecutor must prove that the defendant's actus reus was both the cause in fact and proximate cause of the harm or injury suffered by the victim. Like in tort law, the harm would not have occurred to the injured party but for the defendant's actions. In our criminal context, proximate cause is usually straightforward. For instance, if a defendant stabbed another in the stomach and the victim died of exsanguination before the ambulance arrived, the defendant's actus reus is clearly the proximate cause, to say nothing of the fact that it was the cause in fact. However, if that same victim was stabbed and then killed in an auto accident while en route to the hospital by ambulance, a question of proximate cause can arise. The general rule is this. All natural and probable results of the defendant's actus reus are, in the criminal law, deemed to be proximately caused by him. So, in our ambulance hypothetical, the fact that the stabbing victim died because of a car accident is unlikely to break the causal chain, linking his death to the defendant's actions. This fact pattern can be classified as an act by a third party. In light of this, let's spend some time on intervening acts just like this. An intervening act may be sufficient to break the causal chain of proximate causation. There are three types that may accomplish this. 1. An act by a third party. 2. An act of nature. And 3. An act by the victim. We've already touched on an act by a third party with our ambulance hypo, and based on those facts, it's unlikely that the causal chain was severed by the car accident. However, Had the car that slammed into the ambulance carrying our stabbing victim, and which ultimately caused his death, been driven by a drunk driver, a driver that was speeding dangerously over the speed limit, or by a driver of a getaway car after a bank robbery, then that may sever the causal chain with regard to the man wielding the knife. Ultimately, it would be a question for the jury as to whether the victim's death by drunk, reckless, or speeding getaway driver was sufficiently unforeseeable to sever the causal chain to the victim's attacker. For this, let's stick to the ambulance hypo. When our defendant stabbed our victim, who was then being transported by ambulance to the hospital, let's say that it was not raining, but en route to the hospital it began to pour. In fact, so badly that as the ambulance was transiting a low-lying stretch of road, it was swept away by a flash flood, killing everyone in the ambulance. Here, these events may be sufficient to sever the causal chain. When the stabbing occurred, there was no rain, and the area was not prone to the kind of flooding that eventually overtook the ambulance. In this case, the flooding, while a natural event, was not foreseeable when the stabbing occurred. It will likely be an independent, intervening cause, and as such, it is arguably able to sever the causal chain. An act by the victim may or may not serve to sever the causal chain. The two hypotheticals law students will encounter here is usually 1. A victim with religious beliefs which forbid medical intervention, or 2. A victim that later commits suicide. In most jurisdictions, the fact that a victim refuses treatment because of his religious beliefs will not be sufficient to break the causal chain. The reasoning behind this is that, just as in torts, the defendant takes his victim as he finds him. That same thinking underlies a victim that commits suicide, though the reason why the victim does so may change that determination. For example, a victim that kills herself because of unbearable pain resulting from the injury inflicted by the defendant is unlikely to break the causal chain. Compare that to a victim who kills herself while being treated in hospital because she has a history of untreated mental illness quite separate from the injuries caused by the defendant. Those facts may serve to break the causal chain. However, all these hypotheticals can be argued the other way. In the real world, the determination would depend upon the precedents established in the jurisdiction in which the crime occurred. Keep that in mind when you're answering questions such as these on an exam. It's generally a good idea to argue the other way and then close by saying why that alternative outcome is unlikely. As we've seen in our mens rea and actus reus videos, the common law can be an adjective and adverb-filled morass. It is judge-made and varies over time and space. In contrast, legal scholars created the MPC and did so all at once. The MPC attempted to create a model code without the common law's ambiguities, vagaries, and passion for literary flourish. So let's take a look at its provisions regarding causation. Section 2.03 subsection 1 of the MPC provides that conduct is the cause of a result when a. It is an antecedent but for which the result in question would not have occurred, and b. The relationship between the conduct and result satisfies any additional causal requirements imposed by the code or by the law defining the offense. Keep in mind, however, the but-for causation described here is not the sole determining factor of causation. The MPC examines causation as it relates to one of the four mens rea categories described in Section 2.02. Despite the MPC's high ambition of verbal clarity and avoiding the grammatical twists and turns found in the common law, it was not always successful. Section 2.03's double negatives are a good example of this, so it will take some time to unpack it. Section 2.03 subsection 2 provides that when purposely or knowingly causing a particular result is an element of an offense, the element is not established if the actual result is not within the purpose or the contemplation of the actor, unless a. The actual result differs from that designed or contemplated, as the case may be, only in the respect that a different person or different property is injured or affected, or that the injury or harm designed or contemplated would have been more serious or more extensive than that caused, or b. The actual result involves the same kind of injury or harm as that designed or contemplated and is not too remote or accidental in its occurrence to have a just bearing on the actor's liability or on the gravity of his offense. Okay, let's take both of these apart. Subsection A's provisions are very much like transferred intent under the common law. If D set out to shoot A, but the round impacted B, then under the MPC provisions, D is culpable for the harm to B. The second part of subsection A, the quote, injury or harm designed or contemplated part, is illustrated by the following example. Suppose D set out to kill A by putting arsenic in his drink over a few weeks before this is discovered. But instead of death, A becomes so neurologically damaged that he can no longer live on his own without assistance. In that instance, the injury or harm designed or contemplated, death in this case, would have been more serious or extensive than the neurological harm and permanent disability caused by the poison. Nonetheless, the harm contemplated would have been sufficient to hold D culpable for attempted murder. Subsection B's provisions exist for situations in which an actor intended injury or harm to another, and that other became injured or harmed as a consequence of a separate action that, it can be argued, would not have occurred but for the actor's prior act or conduct. For example, D robbed A, and in the course of doing so, D knocked A unconscious. Let's suppose these events took place in January, in Michigan, at night, and the temperature is subarctic. A froze to death while unconscious and exposed to the elements. In this instance, D would be culpable for murder despite the fact that when he robbed A, he had no intent of killing him. Section 2.03, subsection 3 provides that when recklessly or negligently causing a particular result is an element of an offense, the element is not established if the actual result is not within the risk of which the actor is aware, or in the case of negligence, of which he should be aware, unless A. The actual result differs from the probable result only in the respect that a different person or different property is injured or affected, or that the probable injury or harm would have been more serious or more extensive than that caused, or B. The actual result involves the same kind of injury or harm as the probable result and is not too remote or accidental in its occurrence to have a just bearing on the actor's liability or on the gravity of his offense. Section 2.03 sub 3 examines acts done recklessly or negligently in the same way as those done purposely or knowingly. So I will refer you back to what we just covered for any detailed look at this. The only difference between the two is the mens rea categories. Again, those of recklessness or negligence. This lesson's purpose was to provide an in-depth look at the third and fourth elements composing a crime, concurrence and causation, in order to better understand the specifics of all criminal offenses. We began with a brief lesson introduction, discussed why these elements were necessary, and we looked at concurrence before looking in depth at causation from the perspectives of both the common law and the model penal code before concluding the lesson here. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.